Good morning, everybody. As the Secretary mentioned, my name's Scott Willis, and I'm the Director of the Business Services, of which Notary Commissions is one of the things that we take care of in our office. And I wanted to also thank you for your service, and thank you for all the things that you do, and encourage you to reach out to us if you do have a question related that we can help with. We'll do the best we can to get you an answer. We may not always be able to give you an answer that very minute. Even some of the questions that you folks had that Stacy shared with us in advance, we had to seek out legal expertise because it was beyond our scope of understanding. So we did try to do that. Mandy has some answers to some of those, and we'll present some of them today, and we'll take any questions that you have with this. But I also wanted to take a minute to recognize this young man too. Zach Grosher's been with our area 7 years, is that right? 7 years. He was actually with our call center partner, Net4, before that, and he's vital to me. I could not get stuff done without him. He was instrumental in our HEA 1623, which is where we had to justify our enhanced access fees that people spend to use our InBiz platform. And also, he was instrumental in helping me craft the fraud bill that the governor just signed about a week ago, HB 1593. And that's, as the Secretary mentioned, that's going to do a lot to help improve the accuracy of our records, improve the connection to the governing persons of businesses and people like that, and to hold our third-party filers a little more accountable to know who they're filing on behalf of, because in many cases, that wasn't as evident as we'd like it to be. So know that we're doing those type of things. You'll start to see the actual impact of that in the coming months as we do more modernization and stuff to the InBiz platform. But with that, I'm going to let Zach go through the presentation. Again, any questions you have, you can interrupt him, go through it. This is for you guys. This is not, just a presentation. We want to try to answer questions or clear up any confusion that we can.
Thank you, Secretary Morales and Scott, for the kind words. I will do my best to fill those great big shoes you left for me. So appreciate it. Thank you all for having us. We appreciate the opportunity to get in front of you and help out with your questions that you have about anything our division does. And like Scott said, anything you have questions about, even if we don't know the answer off the top of our heads, we're happy to go run that answer down for you. So I'm going to go ahead and jump in and let's get started. So I'm going to focus my presentation today on Notary. I think there's maybe a little bit of UCC in here. So for some of you, this is old hat, and I'll try to move through it pretty quickly. But if you have any questions or you need me to, if you want to interrupt me, raise your hand. I'll answer as I go. There are also questions that were provided to our office by Stacy, and I have those towards the end. So if you've asked us a question recently, or you've asked maybe the Recorders Association a question recently about Notary, it's probably on here. And if not, let me know. So what is a notary? A notary, like county recorders, is a public official. They are commissioned by our office for an 8-year term, and they are responsible for independently verifying signatures and being an impartial witness to important legal documents. I want to draw a distinction between what a notary public is and what a notarial officer is right at the top here. Indiana statute permits several different distinct groups of people to have the power to notarize documents or perform notarial acts. My presentation is limited to notaries public, but you should also know that other public officials do have the authority to perform notarial acts. Those are called notarial officers generally, and that sort of umbrella includes notaries public, court reporters, judges, the Secretary of State. The list goes on. So what is a notarization? Notarization refers to the process of documenting a notarial act. Usually we're talking about witnessing a signature or taking an oath from someone. Indiana law recognizes a few different forms of notarial act. There's an acknowledgement you might see. That's where someone has signed a document and they go to a notary and say, I signed this document. The notary checks their ID to make sure they're who they say they are. Verification upon oath or affirmation, also known as the Latin term jurat, which means to swear, I believe. That's a very common type of notarization. The person signing the document signs in front of a notary and swears that everything they're signing to is true. And then there's witnessing a signature, and notaries can also, in some circumstances, issue what are called copy certifications. Notaries public can charge $10 per notarial act they perform. You might see that quoted in some places as $10 per signature. If I witness 10 signatures, that's 10 notarial acts. A remote notary public can charge up to $25 for a remote notarial act. We'll talk more about remote notaries in a minute. And then notaries can also charge a travel fee. Notaries are public officials and they are required to be bonded. By law, notaries have to have a $25,000 surety bond on file with our office, and they have to maintain that for the duration of their commission. The bond's purpose is to protect the public. I believe it was set in 2018, and they did some research or looked into what was the typical cost of basically fixing a bad notarization in court, which is where a lot of bad notarizations would end up needing to get fixed if they go on too long, I guess. But $25,000 was, I suppose, either the median or the typical estimate around that time. And so now under Indiana law, notaries have to have $25,000 surety bond. Previously, they could have up to a $5,000 freehold bond. That is different from errors and omissions insurance, which we do recommend notaries get. In contrast to the notary bond, the errors and omissions policy actually protects the notary. The bond is something that the public could collect on, and then the surety could then collect from the notary on. So it doesn't really protect the notary, that's more to protect the public. Many notaries operate as employees, either of law firms or other organizations. I wanted to mention that a notary working for an employer sort of has two concerns they need to be aware of with their liability. There's their personal liability for their actions as a notary public, but also an employer, especially an attorney who directs a notary to perform, let's see what the Supreme Court says. If a lawyer ratifies a non-lawyer assistant's conduct and is in a position of managerial authority, that attorney could also face discipline through the Indiana Supreme Court. Same goes for an employer. If an employer is telling a notary to do a bunch of bad notarizations, the notary is not absolved of that, and neither is the employer. Every notarization by a notary public should contain a notary seal. I think we'll talk about this more when we get to Q&A, but notary seals, I think we've all seen them. They have to have certain elements like the words notary public, the words state of Indiana, the notary's name, commission number, and their expiration date. One not so trivial element of the seal is that it has to be copyable with the record that it's attached to. So you may see seals that are just embossed, and when you copy them, they kind of disappear. Those are generally not acceptable seals. Notaries must also sign their notarizations in a manner that's consistent with the signature sample they gave us when they first applied for their commission. So we do have also a database of notary signatures, and we expect that when they're notarizing, those signatures match reasonably close to the signature sample we have on file for them. So a notarial certificate is a documentation of a notarization or a notarial act. A notarization is not complete unless there is a notarial certificate. The notarial certificate is really just the notary explaining what happened. You see I've got an example there sort of at the bottom left. On this 17th day of March 2019, this record was signed before me by the signer. That's a very basic, I witnessed the signature, this person signed the document before me. Importantly, notaries cannot decide what type of notarization a customer needs, as that could be considered unauthorized practice of law. Deciding what notarial certificate to document is something that the signer or the person who's actually relying on the legal document should decide. The notary cannot decide that for the customer. All right, before I sort of move into the difference between in-person and remote notarizations, any questions so far? How are we doing, everyone?
Question is kind of goes back to the third slide where it talks about who can notarize, and it lists several officers, including like court clerks, clerk treasurers, trustees, election officers, et cetera. My question then is, are they only to notarize in the capacity of like their duties? So for instance, a clerk treasurer of a town is notarizing for the purposes of the town. And if they do that, what kind of seal should they have? Because most frequently, election officers, legislators, mayors, they don't really have a notary seal. They sometimes, not always, have their city or town seal. So what should we be looking for if something comes in that's not notarized by a notary public?
Sure, great question, thank you. So I'll start by saying our office only administers notaries public, and a lot of the law only, as far as we're aware, applies to notaries public. I think the seal requirement is a great example of that is something that notaries public, people who are commissioned with our office, have to have. It may not necessarily be a requirement for someone like a township trustee. You asked if they could only do that in their capacity as a township trustee, and I think the answer to that question depends on which notarial officer precisely you're referring to. I think legislators have broader notary authority than someone like a township trustee, but ultimately, since we don't do any administration of the other notarial officers, we don't know too much about what their requirements are exactly. The requirements I'm discussing, just for clarity, will only be applicable to notaries public as far as we're aware. I see you. We'll get you. I think we got a couple around here.
So question for you about the embossed seal. So you
Yep.
said that they're not generally acceptable. So we get a lot of documents with the embossed seal and then the information written next to it, like commission number, you know, their name, all that fun stuff. Is that something you would advise against?
For a notary public, their seal can never be corrected. The impression of a seal may not be corrected. They can correct pretty much anything else about their notarial certificate. Say they get a date wrong, they can cross it out and initial the change. But for whatever reason, under Indiana law, the notary seal itself may not be corrected. So if the impression of the seal they first gave on the document wasn't adequate, I don't see how they could then like write something in to correct that. My advice to notaries is if your seal doesn't have all the required information and isn't photocopyable, just get a new one. Get a new rubber ink stamp. They're about $20 online.
So you would say that is not a good seal?
Yes, I would say that's not a good seal. I would tell that notary, hey, maybe time to get a new seal. I would. If you want me to tell them, I'll tell them.
I will take you up on that, absolutely.
I think we had a couple more questions. Yes.
In the assessor at the auditor's office, there are staff that are notaries, and they notarize documents brought in by customers, deeds, et cetera. And I've always told my staff, we won't do that because I'm concerned it would be a conflict of interest. If one of those staff does, you know, get in a position where they've not notarized something correctly, whose responsibility? Does that fall back onto the county?
It could. So we're talking about liability here, and I'm not an attorney. I can't really like assess that whole hypothetical scenario. So if you do have employees who are notarizing, that might be a good thing to really carefully assess. I know a lot of organizations are uncomfortable with having notaries perform notarizations. I think I could say the UPS stores have brought questions about this because they're one of the big sort of notary provider organizations. I guess it would depend on exactly what the error or misconduct was and who told the notary to do it, if the notary was doing it on their own. I'm not sure if that answers your question.
I do know that it's a courtesy service they're providing, which in theory, it's a great idea, but in practice, again, I would be concerned about being a conflict of interest because we're technically a part of the process to get it recorded.
Yeah, and I think it's a good idea for notaries to keep a fair distance away from the documents they're notarizing. I'm not sure in your specific example if that would constitute a conflict of interest or not. Happy to talk to you more about that. But that would be a valid consideration and I think a concern that would need to be kind of worked through. Go ahead.
You said by law the seal may not be corrected. Do you happen to know off the top of your head what that code is?
I do not, but I can get it to you.
All right,
Sorry.
thank you.
3342, looks like she's got it. Oh.
So I see that county recorders is on here, but there's an Indiana Code 32-21-2-3 states documents to be recorded they can't do it while they're in office. So I'm a little confused. Indiana law prevents county recorders from notarizing documents while working in their official capacity. So
Okay. So I'm not familiar with that section of, you said 3321?
32-21-2-3.
And this is an example of, that's sort of the part of the ocean we're not too familiar with. We deal with the notaries public. And so the notary authority of a non-notary public notarial officer, that's deep water to us that we don't tend to venture too far into. Happy to run down an answer for you if you have more questions about that, though.
So, Zach, I'm so happy you're here today because I was going to call
Thanks.
you.
Happy to be here.
And to get deeper in that ocean. Sorry, but I kind of have a problem. I'm going to open up to the room, too. I have a deputy prosecuting attorney that creates documents, submits them for recording,
Okay.
and uses her deputy as her. So in a way, she's doing it as her business.
Okay.
And then she's using her authority and stamp to do that. And so I'm kind of opening up to the room too. Like I did reach out to my county attorney, like, what am I doing with this? Kind of vaguely looked over this code here to say, well, I guess, kind of could be falling under there. Anybody got an opinion on that? This is something I should not be accepting.
So it's a deputy prosecutor who's not a notary otherwise?
Correct. She's using her authority and her seal as the deputy prosecuting attorney to notarize her documents.
And it's a notarization, it's not just her signing documents?
Correct. Yeah, I even have a copy if you want to see it later.
Yeah, I'd love to take a
Okay.
look later. I'm not sure, I just
Anybody
don't know
else
enough to
have that
comment too
problem?
intelligibly about it.
You do?
It sounds
And
like-
do you
yeah.
take them?
They told us that other counties did, and we looked at state code. I think I called Marcia. And we talked about it, and you've gotten them. You're the prosecuting attorney. I called you.
What was the document type?
Deeds and transfer on death deeds.
Tom, did you have something to add?
We get them all the time, we get them, but they're also they're from the law firm of our county attorney, so there's two deputy prosecutors in our county attorney law firm, and they send me on deeds all the time, and our county attorney says, take them. So I said, okay, record as that presented.
It looks like, maybe,
Okay.
one more question?
So I had a mortgage release last week come in, and when it came in, the notary wasn't signed. So I let them know that we were going to have to reject that document because the notary had not filled out their portion. Okay? So it was a local bank, so they were like, just hold it, she'll come over. So I'm like, okay, we can do that. So when she comes over, it is not the person that notarized it. It was another notary, and she just marked through the name and marked through the other information. And she said, she's out for a funeral. And I'm like, well, it's really supposed to be her. And she said, well, it's really record as presented. So I did. But I kind of felt like it was a, like, you can't do that on television kind of moment.
I'd love to hear more about this. We'll talk. We'll talk. All right, I'm going to keep moving. We'll have more time for questions. And like I said, I have some questions towards the end of this. I think you all have a copy of this, right? Okay, very good. So I'm going to move on here to the topic of remote notarization. This is something that is growing in America. It really kicked off in Indiana with COVID. There was a big drive for some reason to do stuff remotely. So remote notarization really came into full effect, I think 2021-ish. But there's a difference between an in-person notarization and a remote notarization. An in-person notarization, the notary and the person meet face-to-face in the same room at the same place. That can be a notarization executed on a paper document, or that could be a notarization executed on an electronic document. So if I have a computerized document and I put an electronic signature on it, but you came to me in person, that could be a in-person electronic notarization. Remote notarization is when the notary is having the appearance of the person through some sort of audio-visual communication. So in Indiana, those have to happen on an approved remote technology platform. You can't just Skype someone, you can't just Zoom someone, it has to be on a platform that has recording standards, security standards. There's built-in identity verification. The notary has to be able to see the person's face on the video. So there's a lot of safeguards built into remote notarization. But I just wanted to illustrate the differences, whether or not the people are in person or separate. You will know if you're dealing with a remote notarization because it will say so, or it should. The remote notarization certificate has additional requirements in Indiana law that include saying where the signer was located. I think it's like city, state, province, that kind of thing. And then it also has to state that it is a remote notarization, and you can see that in my example here, where it says in the red underlined, and who appeared by audiovisual communication on this date.
Question.
Oh, okay, sure.
In the remote notary, I'm just asking, I'm sure I know the answer, but I just want to verify.
Sure.
When they go through their training and before they take their test to be a remote notary or do that extra piece, they are aware, correct, that this is what that certificate should look like it should have where everyone was located. We've been having some pushback lately from a couple of title companies, and I'm assuming it's because that notary may not be there, but they're not wanting to make sure that that certificate is correct. But I'm sure in their training they realize it should appear this way.
Yes.
Okay.
So
Thank you.
this presentation used to cover a lot of what the process looked like to become a notary. For a remote notary, they do have to take an additional education course and exam. That content is presented to them, but knowing a thing and being compliant with a thing. All right. Sort of related to the topic of remote notaries, I did get some questions from this group about notarial acts from other states. What does it mean if a notary's in another state, or they're commissioned in another state but they're in Indiana? What if they're commissioned in Indiana but they're in another state? And first I want to talk about the sort of presumption of validity to notarizations. They are self-authenticating, and full faith and credit is supposed to be given to a notarization from another state just as if it were performed by an Indiana notary. And I know this can get tricky because I'm talking about the requirements for Indiana notarizations, and I'm sure many of you deal with Kentucky notaries or Ohio notaries or Michigan notaries. They may have different notarization requirements than Indiana notaries do. I think all of our surrounding states have slightly different seal requirements, just as an example. So in general, a notarial act performed in another state by another valid notarial officer should be presumed to be valid, just as if it were performed by an Indiana notary. In other words, there is no additional legalization requirement for out-of-state notaries. You don't need to go through some sort of diplomatic process from the from Illinois to Indiana, the document should just be treated like an Indiana notarized document. Indiana notaries, though, may not notarize while they're located out of the state of Indiana. So if you are commissioned in Indiana, you stop having the power to notarize as a notary public once you leave the geographic boundaries of Indiana. So that applies for remote notaries too. The second I cross the border into Michigan, I may no longer perform notarial acts. That kind of goes with reciprocal commissions is a question we started to get. Does an Indiana notary commission grant a commission in any other state, or does a commission in any other state grant a commission in Indiana? And there is no reciprocity in Indiana or out of Indiana that we're aware of. Maybe having an Indiana notary commission gets you something somewhere else. We're not aware of that, and there is no reciprocity into Indiana. That does get a little confusing. I was talking about Indiana notaries cannot notarize while they're located out of the state of Indiana. Other states, notaries can. I believe Kentucky is a good example of they have a sort of separate commission you can get that does allow you to notarize while you're located outside of the state of Kentucky. All right, moving on to, oh, sorry.
Yeah, so you said that the notary is to be treated just like an Indiana notary. So usually when we have an out-of-state notary, we don't necessarily require the Indiana requirements of the prepared by statement and the affirmation statement.
So I'm not sure the prepared by statement would have, is that something, that's not something the notary is necessarily doing, right?
Right, but if it's an out-of-state notary, do the same state laws apply? Because those are recording requirements for Indiana.
I think you would treat, my understanding is you would treat the out-of-state notarization as if it were an Indiana notarization. I don't know how that would interact with specific requirements. Do you have a question, or do you want? Okay.
We went back and forth about this so many times,
Okay.
and we got with Secretary of State as well. And we were told, and I apologize, I'm not remembering the whole, what it was stated. It was called an interstate agreement. And we were supposed to defer to that. So therefore, state of Texas doesn't state that it has to say that it is, as we require, the county, the state, and the country, okay?
I see.
But if you go to their Secretary of State website, they do have certain requirements that they have to say audiovisual. So it's kind of like, if we wanted to, you can go to that and say, okay, because they don't require that. And I was told I had to honor that, to say, okay, we've got this interstate, and there is a code, and I'll have to look it up, and that's what they referred us back to say, it's not our job to police, because Texas isn't going to do it the way those notaries don't know anything about ours, and that we're supposed to accept them with the assumption that it is a good faith notary because that's how it's deemed in their state. And this question does get really gray for us, because then we're back to, should we be policing? That's what we're asking. Should we be policing it, making sure they're doing it the way we want them to do it if we record it, even though it's a notary from a different state? I was told no, but is that different? Is that changed?
Not to my knowledge. Our office would not, we would not want to be dictating what your recording requirements are. I'm familiar with the notary requirements and what an Indiana notary has to do. And so in my head, I try to compartmentalize the document. The only part of the document I really care about is the box where the notary is writing stuff. You mentioned the prepared by statement. Notaries aren't really supposed to be preparing legal documents unless they're attorneys. So in other words, it's a legal question, not a SOS question. I don't want to give you a non-answer. We can talk about it more, and we can do some research on that. All right, jumping into my favorite topic, notary disciplinary action. Discipline is a word that has many meanings. I think in this context, you might consider it maybe more negative. I think as public officials, as officers of honesty and integrity, notaries should be disciplined, not necessarily that we need to be punishing them, but they should have a personal and consistent discipline about their practice. And so a lot of our efforts in communicating with notaries and reaching out to them about maybe errors or mistakes they're making is in the interest of getting Hoosiers better notarizations more of the time. It's not a great experience to be told, trust me, I know, it's not a great experience to tell someone, hey, I can't process your document because the notary didn't sign it, didn't stamp it. So we are really in the business of getting ideally 100% of Indiana notarizations to be good. So to that end, we do have some authority in statute to investigate notary complaints. We can do certain things to a commission if we find a complaint is valid after our investigation. And so the sort of workflow looks like we can either receive or initiate a complaint, we can then investigate that complaint, and then we can take an administrative action on that notary commission. Importantly, whatever administrative action we take on the commission is subject to an administrative appeal through the Office of Administrative Law Proceedings. Some of the things we're going to consider, whether this is just an email to the notary or a phone call like, hey, heard your stamp was missing something, can I help you with that, versus maybe a more serious disciplinary action, are going to be things like what damage was really caused by the notarization? What was the severity or extent of the misconduct? Has the notary made this same mistake in the past? All those things we'll look at. So I know many of you are very helpful at bringing improper notarizations to our attention. We appreciate that. While not everything's going to be, case of the year or, a big smoking gun, even the little mistakes sometimes are worth reaching out to the notary or just cataloging and saying, hey, everyone makes mistakes and we're going to keep an eye on this. If it becomes a pattern, it becomes a bigger problem, we might have a different conversation about it. So some of the different categories of notary misconduct we tend to look at are, there's things like typos, errors, and omissions. It's not worth losing your commission over a date being slightly wrong or a blank not being filled. But then there are more intentional or reckless versions of misconduct that we take a passion and an interest in. We want to protect Hoosiers from things like deliberate notary fraud, overcharging, that kind of thing. Wrapping up towards the end of my presentation, and then we'll get into the questions. I wanted to just point out our InBiz Notary Public Resources page. This is on our inbiz.in.gov website. You go to the top right, Certifications Notaries Public, and that is our sort of one-stop shop for all sorts of different resources. It's more geared towards notaries, what they need to become commissioned, maintain their commission, what they need to do to perform notarizations. It's also where we store our notary guide. It's sort of that orange link in the middle. This is a really good resource for notaries to see what are all the ins and outs of notarizations. It's more or less a document version of what the education content covers. Oops. All right. I'm going to move through the questions. I think you all have this in writing, so I'm going to go through these, and then if you want to expand on it, raise your hand. But then once we get to the end of this, we can do sort of a broader Q&A. So these are some of the questions that were brought to our office by Stacy. Thank you. We're always happy to help. If you have any questions, don't hesitate to ask. Even if we don't know the answer or it's something we don't think we can answer, we'll make a good effort to try and track that answer down for you. So I think some of these we've started to cover just in the sort of intermediate Q&A. But one of the questions we got was, should we reject a document that's missing a notarial certificate? If so, we need legislation to be clear on this. And I feel you on, we're often given a hard time about this. I was the guy who was always rejecting notaries for aposties. So our experience with notaries and notarizations, when we reject a notarization, we're following specific guidance for the filing type that we're receiving. I'm sorry to say I'm not extremely familiar with the different filing requirements at the county recorder's offices. I'm sure you'd be happy to teach me more about that. But when we reject a document for an improper notarization, we are following, whether it's legislation or guidance from authorities. So if you feel like there's maybe a legislative change that's needed, we're happy to partner up and help with that where we can. We've talked about reciprocity. I think we've mentioned the notary police in here. We want to know, like I said, even if it's a small mistake, sometimes, 100,000 small mistakes is no small mistake. Let us know. You can always email us at notary@sos.in.gov, or you can email me. We're happy to take a look, even if it's as simple as, hey, notary, it's time to get a new stamp. We're happy to do that. We don't want you guys to have to deal with that. That's our responsibility. You are not the notary police. I'm not sure we're the notary police, but I think we're a lot closer to the notary police than the county recorders. We talked about what's the difference between notarization and acknowledgement. Notarization's an umbrella term. It's any notarial act. An acknowledgement's a specific form of notarial act. The acknowledgement's unique because the document can actually already be signed before the notary sees it. Question 5, I think, has been brought up to our office previously, and I'm happy to talk more about this. I thought this was a really interesting idea. Someone had asked us if it made sense to index a notary's commission number with the document. So I think the idea would be you should be able to search a notary name or commission number in a county's records to see all the documents they've notarized. That's actually something I've been asked for from law enforcement before. We don't currently catalog notarizations, but that's something that I think could have some utility. So if that's something that interests the recorders, we're happy to partner and help where we can. And then I think these are also really excellent questions. We spent a lot of time, Scott and I, discussing these and figuring out what would this look like. So exciting stuff. We're always happy to make service better for Hoosiers. How can we work together to make it harder for criminals to record fraudulent deeds? I love that question. We want to know that too. We are all about preventing and reducing fraud in Indiana. And I have seen from our notary complaint process what damage it could do when you have basically your house stolen from you. So we want to help with that however we can. I think that indexing commission numbers might be a good technology step to that. But anything we can do, we're offering our full partnership to help reduce fraud. And then UCC, I mentioned we'd have a nugget of UCC in here. Will UCCs ever be SOS-only filings? Can SOS take over UCC from the counties? So I believe a couple states already do this, and this was one of the things Scott and I started to research. So we're open to discussing this. We are currently undergoing some technology changes with our UCC platform. We want to get all UCCs that are filed with our office to be electronic only, online only. That I don't think would be ready this year, but once we're through that development, we're open to have more conversations about that.
I think the important thing around that topic would be us having a general discussion about the types of UCCs that you guys are filing in your offices, understanding the systems that you're filing on. Are you guys all under one consistent system? Two? There's two for the whole state, or? But those are the kind of discussions we'd need to have, because it's partially a technology discussion, because I'm assuming you probably still need access to the records in a ready form for other things that you're in charge of doing, especially around taxes and property and all that type of stuff. So we just have to have a broader discussion. But we're definitely open to discussing it if it makes sense for the majority of the state, or even if we could do it on a partial basis, you could opt into it. I mean, we're open to discussing it. We just need to, get a lot more people in the room so that we understand all the nuances of why it's there right now versus with us, because we don't want to do anything that hurts other folks. I've talked to a few recorders as I've just been out and about, and some of them have said, no, I don't want to give that up because it's a nice revenue source. So, I don't want to, do anything that's going to impact somebody and hurt them in a way that they need it right now versus trying to be efficient. So we'll definitely participate. You just need to, Stacy or whoever, I think, ma'am, you're the new president, whoever would want to get in touch with us, you've got our contact information. We'll be glad to do that. And hopefully, I tried to jot down a lot of the additional questions.
Can you talk in the microphone? They can't hear you
Sorry.
back here.
I tried to jot down a lot of the additional questions that we couldn't, address, especially around the notarial officers and kind of the questions around that. I think if somebody can present that back to us, we'll try to find out who could give us those answers. It's going to have to be a legal source and somebody, and we'll definitely try to feed that back to the group. Because I understand what you're going through. And, I also know how stuff happens. Sometimes people do things because they've been doing it for a long time, and it may or may not be perfect to statute and all that. So we just all need to know. We're all trying to do a good job. We're trying to do what's required of us, and we want to help support that. So that's all we have, unless there's additional questions. We're glad to stay for any other questions.
I'm coming.
Back on the notary misconduct page, there was an example of where a 0 and a 1 was written over it. Should it can only be corrected by the notary.
You're referring to the blank there, right?
Yeah.
So it can only be corrected by the notary. Should they mark it out and correct it and initial it? Or is there the best practice way to do that?
Yes, that is the best practice. For the notary, they cross out the error, make a correction, and initial. And it should only be the notary correcting the notarization. It should not be a different notary or a random person or any of your staff. It's the notary's responsibility. They made the mistake, they have to correct it.
And this was actually an example of the blank.
Yeah,
not
that's
leaving it blank.
another
That's
common.
a valid point.
Yeah.
Oh, I see we got a couple more.
Okay, so if the name is the same throughout the document, like the grantor name is like John J. Smith, it's that way in the notarial statement, but the person only signs J, like first initial period Smith, or John Smith, so it doesn't match, it's not consistent. Should that notary, isn't it the notary's job, like, do they go by what's in the document, or are they going by the signature that's on their ID? Because it makes it hard for us sometimes, without policing, to make
Yes.
sure it matches and it's the same name throughout the document.
Yeah, and it's tricky. We've had a lot of, we've had a lot of conversations too about, someone's signature is a very personal and unique expression of they're making a mark to signify that they did this thing. And so it's hard to dictate for a notary or for our office, or I'm sure for the recorders, to say, no, you didn't sign that right. Well, that's their signature. That's how they signed it. So there are standards for this. I think the best practice is that the signature is, that the notary makes sure that the name that is signed matches the ID that they were presented, and that should also match, obviously, the name of the person in the document. Your example, if they sign J. Johns, but their name is Jacob in the document, it's a little tricky. If it was Sarah Johns, but it's Jacob in the document, that may be something different. But a shortening of the name, or maybe the signature is illegible and there's just a little squiggly bit that's supposed to represent the latter half of the name. It's a tricky thing for the notary. The best practice is that the notary makes sure the name that's signed on the document matches the ID and the name that the person claims to have in the document. But we also acknowledge that a signature is never really a precise typed, otherwise it'd just be a typed name. It's never quite a perfect representation of just the name. There's some style to signatures, right? I'm not sure if that answers your question, but I guess you want to know if you should reject for that.
I think that again falls under legal advice, and I'm not trying to dodge the question, but I've been in business 42 years, And I will tell you, an attorney will tell you that if you're signing a legal document, you should sign it as the document is made out. Whether somebody could press that in court and make the document defective because you didn't do that, I'm not sure. Again, that kind of gets into case law and how people would judge things, because I would, I could make an argument that I had it notarized, this notary saw my ID, I just signed my name, J. Smith, because I got tired of spelling out Jacob all the time, right? And, again, we're dealing with, everybody does things differently. I've signed my names a lot of different ways. I've always signed it one way if it was something legal, like buying a home or something like that, but that's the challenge with that. I think that needs to go on the list, whoever might be making notes of, we can ask the attorney about that. That's the best, we can at least get that. But it's a valid question. I could see how you could run up against that all the time. Do we have something else in the back?
So on the notarial certificate, in your example, it doesn't show that the notary has to state whose signatures they witnessed. That is not a requirement for the notary clause?
Yeah, I kind of had always thought that was a requirement, but the name of the person signing a document, it's not in the statute as a requirement for a notarial certificate. I think it should be there. I think it's absolutely a best practice, but I don't think I'd have a leg to stand on if I told a notary, you didn't write the person's name on it. That'd be good advice for notaries. I think they should do that. But as far as I'm aware, that's not strictly a requirement for notarial certificates.
Yeah, and we're seeing some of the certificates don't include the signer's name in them, and I'm thinking, well, they could have just blankly signed all these forms saying they witnessed whoever signed it, and they don't have to include their names.
Sure. And loose certificates are a big concern. If there's a notarial certificate that's generic and it's just floating around, or even if it's not generic and it has the person's name and stuff on it, and it's just a single piece of paper, you could take that paper and attach it to something else and make it look like it got notarized. So that is a valid concern. The notary does have some obligation to make sure their certificate is securely attached to the document that they're notarizing, or it's contained within the document. But for whatever reason, the name of the signer is not strictly required in a certificate.
We get this several times on plats when they come in, and there might be 3 or 4 different owners, and then it's the same. And I will tell you, we refused, I know I'm kind of a rebel, but we do not accept them, and we make it go back, and we make the notary, we tell them to take it back to the notary. We let them write their name in with the notary's initials, but we will not accept a document with that blank line, or we don't accept it if the name is not specified, especially if there's more than one signature on it. I'm just saying, that's just our policy in our office, and so far, nobody has really challenged us, and the ones that did, it didn't matter.
I think that's another interesting case for the name. I've got several signatures here, but I didn't say which one I notarized. Is the notary necessarily doing something wrong there? I'm not sure, but I definitely understand the concern and where that's coming from. I would say the notary should say what notarial act they did and who they did it for, and it could be a problem if, say, person number 3 says, I didn't ever sign that document, and now it looks like the notary notarized a signature that the person says they didn't sign.
Going back to the notaries out of state, if a notary lives in Ohio, works in Indiana, and has an Indiana notary, but they sign that their county of residence is an Ohio county, is that acceptable?
So the county of residence is also known as the county of commission because you don't necessarily reside in the state of Indiana. So if I live in Ohio and I work in Indiana, my county of commission or county of residence is actually the county in which I am employed in Indiana. So that is the county they should be putting on their notarizations, is the county in which they're primarily employed. That's actually something we assign to them when they apply with us. We check with their employer what county are they going to be working in, and we give them that county of commission.
So if they live in Mercer County, Ohio, and work in Adams County, Indiana, it should still say Adams County and not Mercer County, Ohio.
It should
Okay.
not. It should never have an out-of-state county for the county of commission or county of notarization. Yes.
I had a situation week before last that I contacted your office about, and I appreciate your guidance on that. I had an attorney, the entire notarization was on the bottom of the second page, but their notary stamp was on the top of the first.
Yes.
And the attorney was very angry with me because I rejected the notary. All I wanted them to do was put the stamp with the actual notarization. They wanted me to provide in writing where it said they should do that, which it is on page 16, number 6 of your notary guide.
Oh, okay.
My question is,
Very good.
is that notary guide a guide, or is that like code, that is what they're supposed to do?
So it's a guide. I don't know that, the guide is based on the legal requirements for notaries. So there's nothing that I'm aware of that's like inaccurate in the guide. It's not code though, it's not the statute. So it's written as a guide for the notaries. But I often cite the guide to notaries and I say, hey, look at the guide at this page. That'll tell you what you need to know to do this right going forward. And that's my approach for situations like that is, hey, this is what the guide says. I think we're out of time. Thank you very much.